In the recent past, we have witnessed several cases where the Office of the Director of Criminal Investigations and other government agencies have attempted to prefer criminal charges against advocates over alleged offenses committed by advocates in the course of their discharge of professional duties to their clients. We are concerned that this increased trend is intended to frustrate the ability of our members to render competent services to the public, and that the actions constitute a threat to the rule of law and the administration of justice. We wish to refer to an event that occurred on Friday last week, and the background of it is that on the 20th of July 2022, a company known as Munyoro Investment Limited instituted proceedings at the Land and Environment Court at Nairobi under case number E242 of 2022 against one John Michael Ogas and Columbus 2000 Limited in a claim of ownership over property reference number 209 of 1/12077. Also listed as one of the defendants in the case was the Chief Land Registrar. The case was responded to through a statement of defense and counterclaim by the firm of Ombok and Award Company Advocates LLP, and which firm had been retained by Mr. Ogas and Columbus 2000 Limited for purposes of defending the suit. While the dispute is pending determination in court, the DCI decided to summon several key witnesses in the case for alleged investigations into the validity of documents relied on as evidenced by Mr. Ohas and Columbus 2000. Among those summoned were Mr. Ohas' son and co-director of Columbus 2000 Limited, Mr. James Hilary Paul Otieno, and Mr. Bernard Ongechi, one of the witnesses who was lined up to testify on behalf of Mr. Ohas. The case was scheduled for hearing on the 21st and 22nd of June, but on the 16th of June 2023, the advocates for the plaintiff wrote and informed the other parties that the Deputy President, who is a witness in the case, was unavailable to testify due to his work schedule, and indicated that he would be seeking an adjournment on that ground. On the 16th of June 2023, Mr. Moses Award Advocate visited the Milimani Law Courts, where Mr. James Hilary Paul Otieno had been detained for purposes of representing him in court. He was arrested and charged under police file case number 122/225/2023 on account of several accusations similar to and in addition to those against Mr. James Ohas. The charges against Mr. Award included uttering a false document contrary to section 353 of the Penal Code. He was also charged with 3 counts of making a document without authority, contrary to section 357A of the Penal Code, and also charged with a charge of involvement in a conspiracy to defraud, contrary to section 317 of the Penal Code. It goes without saying that this is a well-choreographed plan by the DPP and the DCI to invalidate the documents in support of the case and give undue advantage to Wamunyoro Investment Limited, whose director is the Deputy President, the Honorable Rigathi Gachagua, and therefore deprive of the defendants of their justiciable claim over the property. The best practice in such cases is to defer any criminal charges until after the conclusion of the civil crime, to prevent a situation where the High Court and the Criminal Court arrive at two different conclusions. This is a time-honored tradition, and therefore the failure to observe such basic rules points to an ulterior motive that is intended to defeat the cause of justice. These actions are not an isolated incident. We have received several complaints where the Office of the Director of Criminal Investigations have recommended charges against advocates for discharging their professional duty. Indeed, we have severally had to intervene with the Director of Public Prosecution to stop such intended prosecutions. The common denominator in all those cases is the fact that the charges are intended to aid one party in a civil dispute over the other party. Regrettably, those charges have been approved by the Office of the Director of Public Prosecutions, despite the fact that those advocates have complied with internationally recognized standards of professional duties, standards of practice, and ethics. Further to this, the United Nations Basic Principles on the Role of Lawyers requires the government to ensure that lawyers are able to perform all of their professional functions without intimidation, hindrance, harassment, or improper interference, and that advocates shall not suffer or be threatened with prosecution or administrative, economic, or other sanctions for any action taken in accordance with recognized professional duties, standards, and ethics. The Law Society is further seriously concerned at the recent public spat between the Inspector General of Police and the National Police Service Commission over the promotion of over 507 officers above the rank of Superintendent of Police by the Inspector General. The Law Society is of the considered view that the plain reading of Article 245(4) subsection C does not donate any power to the Inspector General to make any appointments or determine promotions and transfers within the National Police Service, as those are functions exclusively reserved for the National Police Service Commission under Article 246 subsection 3A. The intention of Article 245(4)(c) is to insulate the Office of the Inspector General from external pressure in the discharge of his functions, including pressure to make any appointments or transfer. The National Police Service Act at Section 10 does not give the Inspector General of Police any of the powers he has attempted to exercise. On the other hand, the National Police Service Commission Act donates the power to appoint, promote, and transfer on the Commission. Additionally, Section 10(2) provides that the Commission may delegate to the Inspector General the power to recruit, appoint, or promote police officers below the rank of Superintendent. It therefore follows that the power to appoint, recruit, or promote officers above the rank of superintendent is exclusively reserved for the Commission by both the Constitution and statute. The actions by the Inspector General of Police therefore amount to serious violation of the Constitution, and both the National Police Service Act and the National Police Service Commission Act, as well as the Promotion Regulations of 2015, and is a ground for removal of the Inspector General from office. The Law Society is apprehensive that the actions of the Inspector General will create confusion and anarchy in the management of the police service and is therefore a threat to national security. The Law Society shall immediately instruct an advocate to petition the High Court to pronounce itself on the law so as to clear the current impasse created by the actions of the Inspector General of Police. Further, and in order to maintain the rule of law and allow legal professionals to fulfill their role in protecting the rights and freedoms of Kenyans, the Law Society urgently calls on the Office of the Director of Public Prosecutions and the Office of the Director of Criminal Investigations to 1. Ensure all lawyers are able to assist their client without intimidation, hindrance, harassment, or improper interference, and without threats, prosecution, or sanction for any action they take in accordance with internationally recognized professional duties, standards, and ethics. 2. The Office of the Director of Public Prosecutions must safeguard public interest as required by Article 157 of the Constitution and resist any threats or intimidation to prefer charges to aid ulterior motives. C. We call on the government to take all reasonable steps to guarantee the security of advocates as they undertake their duties, including the eradication of any threats or intimidation in the course of duty. Finally, the Law Society urges the Office of the Director of Public Prosecutions to uphold their oath of office and to independently apply the decision to charge guidelines. Ladies and gentlemen, the scenario we are witnessing in this country is a scenario where we are having weaponization of independent agencies that are intended to ensure the safety of each and every one of us. We are not just concerned that it has started with the advocates. We are worried that this trend of using offices, independent offices that have been established under the law and under the Constitution to protect and preserve public order, that those offices are now being used for purposes of aiding ulterior motives. This, if not checked, will result in a watering down of all the other constitutional and independent offices, which is a breach of our Constitution, because the architecture of our Constitution is such that the independent offices are intended to be a check on and act as a restraint on abuse of power by those who are in positions of authority. So when you witness the Office of the Director of Criminal Investigations being weaponized and being used to give undue advantage to parties in a civil case, then that is a situation which we must condemn, and condemn in the strongest terms possible. And we will be, as a society, taking all the action to ensure that we not only protect our members from this interference, but we also ensure that members of the public are safe from this situation, because unless controlled, within a very short time there's going to be a complete breakdown of law and order in this country.